Okay, so if you're involved in any kind of building project in the UK, you need to listen up. The rules have completely and utterly changed. And what you don't know about these new laws could have some very serious consequences. Today, we're going to break down exactly what has shifted and, more importantly, what it all means for you.
So, are you an organization thinking about new offices? Maybe a developer with a new site on the books? Or, hey, even if you're a homeowner just planning a simple extension? If you are commissioning any building work in England, the next few minutes are absolutely essential. Because of something called the Building Safety Act of 2022, the old way of doing things is officially over. And this isn't just some small tweak, it's a massive reform that puts you, the client, right in the legal spotlight.
So, why the huge shift? What on earth was the catalyst that forced a complete rewrite of the rulebook for building safety? Well, this entire journey really began with the absolute tragedy of the Grenfell Tower fire back in 2017. That disaster kicked off a complete top-to-bottom reevaluation of building safety, which led to a major review, then the new act itself, and that brings us to today. The grace period is over. These new rules are now fully in effect. That review I mentioned, led by Dame Judith Hackett, it uncovered some profound systemic failings. It found that, a lot of the time, the people designing and building things just weren't competent enough. The systems for checking compliance, totally unsatisfactory. And, maybe most crucially, the penalties for getting it wrong were barely a slap on the wrist. They just weren't a strong enough deterrent. This new act was designed specifically to fix all of that.
The Act's core solution is a brand new framework of accountability, and it's all built around specific, legally defined roles known as duty holders. To create this chain of accountability, the law now defines 5 key roles or duty holders. Think of this as the core team that is legally on the hook for making sure every single stage of the project is compliant.
And who's sitting right at the top of that list? The client. Under this new law, the client isn't just the person footing the bill anymore. No, you are now the absolute linchpin of the entire compliance process. If you're commissioning the work, then in the eyes of the law, you're the client. Simple as that.
Now, this is a really crucial point, so pay attention. These roles might sound familiar if you know anything about CDM regulations, right? But those are all about health and safety during construction. These new building regulation duty holders, let's call them BREGS duty holders, have a completely separate legal job to make sure the finished building complies with the rules. They are not the same thing, and it is vital you know the difference.
Okay, let's dive into the nitty-gritty, because this is the part that directly affects you as the client. What exactly does the law now expect from you? This right here is basically your new mission statement, pulled straight from the regulations. You have to create and maintain the right arrangements for planning, managing, and monitoring the project to ensure compliance. That responsibility, it starts and ends with you.
And that big overarching duty, it breaks down into these key responsibilities. We're talking about appointing competent people, allocating enough time and money for things to be done right, making sure your team is actually cooperating, giving them all the information they need, and, this is a big one, constantly reviewing these arrangements throughout the entire project.
And this right here is a major shift. You can't just assume your architect or builder is competent anymore. The burden of proof is now on you to take all reasonable steps to verify they had the skills, the qualifications, and the experience that's required for the job.
Okay, so what about homeowners working on their own house? Well, you do get some protection. For domestic clients, that primary duty to make all these arrangements gets automatically passed to the contractor by default. But, and this is important, you still have a responsibility to make sure that's actually happened and been accepted. You can't just wash your hands of it. Now, to help you meet these obligations, you're going to appoint and rely heavily on 2 key roles, the principal designer and the principal contractor. Think of them as your key allies in this, the ones responsible for managing and signing off on the compliance of all the design work and all the building work. So, what happens if these duties are ignored? This is where the new act really bears its teeth. The consequences for noncompliance are now more serious than they have ever been. To put it bluntly, this legislation has given the old Building Act of 1984 some serious bite. The new penalties are specifically designed to be a powerful deterrent against cutting corners or trying to plead ignorance. A perfect example is the enforcement window. Previously, the authorities only had 12 months to tell you to fix or remove work that wasn't compliant. that has been massively extended to 10 years after completion. 10 years!
The direct penalties have also been seriously ramped up. Fines for breaches can now be unlimited. Yes, unlimited. And the potential for prison sentences for serious offenses has also been increased.
And the accountability now goes right to the very top. It's not just the company that's on the hook. Directors and other corporate officers can now be held personally liable for an offense if it happened with their consent, their involvement, or even just through their own neglect.
So, what's the ultimate takeaway from all of this? It's simple. The project being finished no longer means your responsibility is over. Your legal liability now stretches for years and years into the future, which makes it absolutely critical to get compliance right from day one. The game has changed, and as the client, you are now player number one.